Morning. Welcome to the HR Law program. My name is Alan White, and we've had our introductions offline. So let's get right into the first session, which is an overview and a review of the legal framework, which underpins the rest of the topics, the other 5 topics, actually the other 7 topics that will be coming in the balance of the program. So the sessions are set up in essentially 4-day quadrants. The first 2 days are in this new course that's been developed, are being delivered over the internet, so to speak, in an online way. So today the slide is a little different for today's purposes. Today we're going to be doing the overview and legal framework and the Employment Standards Act, and then we're going to skip over to the attendance and disability management. And then on day 3, a human resources consultant will come in and deal with issues like recruitment and performance management and that kind of thing. And then on day 4, I'm going to come back in a live session and we'll do managing in a unionized environment and discipline and termination. So that's the high-level layout of the program. So let's start with, we're sort of at a fairly basic level here, but I think there is a lot of misunderstanding among employers about why the law is the way it is and what the actual sources of the law are. So on this slide, we're going to end up with about 6 items on this slide. We talk about the sources of law in descending order. So number 1 is the Charter, the Canadian Charter of Rights and Freedoms, and it is the supreme law of the land, and nothing else trumps the Charter. Having said that, in my experience, the Charter isn't a big factor in the day-to-day administration of a collective agreement or the day-to-day dealing with employees in an Ontario workplace. People throw the term around, but it's not something that, as a practical matter, is directly dealt with, but it's still out there, and sometimes there are legal arguments in arbitration or in other contexts that are based on the Charter. So then in descending order, the next layer, if you like, in importance is what we call quasi-constitutional legislation, and the best example of that in Ontario is the Human Rights Code. So although the Human Rights Code is a statute and is a piece of legislation just like the Occupational Health and Safety Act and the Employment Standards Act and other, the Municipal Act, it has a particular, the way it's been interpreted, and actually there's a section at the end of it that essentially says this, is that it has primacy over other acts. So that it trumps everything else unless the other act specifically provides that the Human Rights Code does not override that other act, if you follow me. So it has a particular status in Ontario law, and that's part of the reason why we're going to be spending a fair amount of time in this course talking about human rights. The next layer is what I was just speaking of, standard legislation. And the most important pieces in this course that we're going to be looking at quite closely are the Employment Standards Act. I'm going to call that the ESA from now on, just for short form, and the Occupational Health and Safety Act, and I'll probably refer to that as OSHA every so often. So that's just legislation, and of course many pieces of legislation have associated regulations, and that's the case in both ESA and OSHA, that there are regulations which actually are quite important that affect how you conduct yourself in the workplace. So a good example of that is WHMIS. We've always heard, or you've heard of WHMIS, obviously, and many of you in the room, I'm sure, have undergone WHMIS training. WHMIS is actually a regulation under OSHA. Okay, so there's an example of how the two things work together. The next layer down is collective agreements in the unionized sector and employment contracts in the non-union sector. Everyone knows what a collective agreement is. It spells out not every, but most of the terms and conditions of employment of the employees in the bargaining unit. So, as you can tell from the descending order that we're going through, collective agreements are inferior, if you like, to legislation and the Human Rights Code. So if there is a conflict between a provision in a collective agreement and something in the Human Rights Code, the Human Rights Code is going to govern because it's a higher order thing on the list. Same thing with employment contracts. I don't know how many of the municipalities in this room regularly utilize employment contracts for their non-union employees. Some do, some don't, I find, in the municipalities that I act for. Often it's the larger municipalities that seem to use employment contracts more often, but there's no hard and fast rule on that. But again, the intention is to set out the terms and conditions of employment, and it has to comply with both legislation and the Human Rights Code in its terms. The next general and very broad category, which we're going to review in greater detail in a moment, is generally the body of law called common law. And common law is essentially judge-made law. Although as we'll see later, I'm going to broaden out the concept of common law a little bit, but for this slide's purposes, let's just talk about the common law as being produced by the courts. And it's the case law that is decided virtually every day on individual cases that require adjudication by the courts because the parties haven't been able to settle them. And often there is interpretation of statutes or sometimes the Human Rights Code or even the Charter as the cases are individually decided, and that creates a body of law, sometimes referred to as jurisprudence as well. That's another fancier word that is sometimes used, which just develops over time and it evolves. And as lawyers, we're expected to keep up to date on that evolution. We're expected to read the cases and become aware of the developments and the trends so that we can provide good legal advice on any individual case that comes up. So we're going to talk about wrongful dismissal in this course. The basic principles of wrongful dismissal are very well established and have been for at least 50 years. But there are trends within the narrow category of wrongful dismissal law in terms of notice periods and how just cause is looked at and so on. And so that's what lawyers such as myself who specialize in this area, we stay up to date on and advise clients on. Finally, the least most significant, if I can put it that way, item in the list is employer policy. Now, we are going to talk about policies a fair amount in this course. They are important. They set out the expectations that you as the employer have for your employees in terms of conduct and behavior and procedures and the like. I know that those of you who are involved in the HR function hate dealing with them. They're hard to get. They're usually not very pressing, and I find they're usually at the bottom of the to-do list, and they often get pushed from month to month and year to year. But I think in this course you'll learn the importance of policies because they can actually save your legal position or at least assist your legal position very significantly in any particular case. If you discipline an employee for some period, for some incident or item of misconduct, if you have a policy that's well drafted, clear, and has been communicated to the employee, which sets out your expectations for behavior in whatever the relevant area is, and then the employee breaches the policy, you have a very good basis for discipline or termination or whatever the case may be. You may not you may not be completely out of luck if you don't have a policy, but it just assists your position legally to have such a policy. And as we're going to learn, there are some policies that are actually mandated. There's actually a surprisingly small list of policies that you must have, but there is a very long list of best practices policies. And I imagine that most, if not all, of the municipalities in this room have policies to some extent, probably in varying stages of development and currency, shall we say. So any questions on any of that? Okay. So moving on, quick review of the Charter, which, as I say, is not something that you deal with on a day-to-day basis, but there's these 4 sections, 2, 7, 15, and 32, that are the most relevant sections in the Charter. And one of the readings that I referred to, which relate to this particular course, the overview course, is actually the Canadian Charter of Rights and Freedoms. A lot of people have never read the Charter. They just hear about it. So we thought it would be useful to actually make it part of this course. So you can, it's not a long document. It's only about 40 sections. And so you'll be able to read it when that material becomes available. From my perspective as a labor lawyer, the section in the Charter that is the most relevant, or the one that I encounter the most often, is Section 15, which provides for equal protection and benefit of the law without discrimination. So there is an overlap between the Charter and that section that I just mentioned and the Human Rights Code, which obviously prohibits discrimination on a certain number of grounds that we're going to talk about in some detail. So the discrimination phrase and the grounds covered by Section 15 are not spelled out in any detail. It's actually a very short section. So it has fallen to the case law to define what Section 15 means, and the Supreme Court of Canada has had a few things to say about that over the years. But as I say, I haven't put a huge emphasis on the Charter in this course because I find that it's not something that you refer to very often on a day-to-day basis. So then we move to the next layer, and that's the quasi-constitutional laws, and in particular the Human Rights Code. So that important piece of legislation sets out or provides for equal rights and opportunities without discrimination, and we're going to talk a bit later on what discrimination actually is. I mean, people have a general notion of what it is, but there is case law that's developed about how to define it and how to look at it and how to think about it. But we'll leave that for a later part of the course. And then there are the Human Rights Code is circumscribed in the sense that it covers 5 social areas. That's the phrase that's used. The one that's most important for this course is employment, but in addition, housing, contracts, goods, services, and facilities, and membership in vocational associations and trade unions. So if an applicant brings an application to the Human Rights Tribunal, which is where applications now are filed, and they can't demonstrate that it falls within one or more of those 5 social areas, the application will be dismissed. Now that's not usually an issue in the human rights cases that you people will be involved with in your work. That will be a non-issue likely, because clearly the issue will fall within the social area of employment and you move on from there. But when I was serving as a vice chair at the tribunal, one of the layers of analysis that we brought was just what social area is engaged. And many people were surprised to know that if one neighbor yells a racial epithet at his next door neighbor, and then the yeller decides to file an application, there's probably no basis for that application because it doesn't fall within that social area. People have a general sense that the human rights sort of covers everything, that that there is a general right against discrimination that comes out of the Human Rights Code for all aspects of life. And that actually isn't true. It's got to be grounded in one of those 5 social areas. And then, as I mentioned, there's a section at the end of the code which talks about the fact that the code has primacy over the other acts. But as I said, if the other act prescribes otherwise, then that primacy doesn't exist. So now we're going to move to the next layer, and that's the other employment-related legislation, some of which we're going to look at in detail in this course, some of which we're not. That we had to make judgment calls about what was going to be most relevant to you folks in designing this new course. So we have a whole section that we're going to get to later today on the Employment Standards Act. We have a whole section that we're going to get to tomorrow on OSHA. We're not going to spend a lot of time on the WSIA or the WSIB system. Sometimes, though, there are WSIB cases that will have a human rights element in them or some such thing. So if you do, I'm not trying to preclude WSIB. If you have a situation that you've dealt with or you're currently dealing with that comes out of a WSIB case, but it relates to something else that we're talking about, I mean, feel free to, ask a question about it or comment on it in some way. Another act that we are going to talk about is the Accessibility for Ontarians with Disabilities Act, usually referred to as the AODA, and that's becoming or has become increasingly important because of the passage last summer in 2011 of what's called the Integrated Standards Regulation, and it has an employment component to it. So we've included in this course that particular component. We're not going to do a comprehensive review of the AODA as it relates to customer service and other aspects that are unrelated, usually unrelated to the workplace. And then, of course, there's the Labor Relations Act, and that's most relevant to the unionized workplace. And obviously the Labor Board which is the tribunal that administers the Labor Relations Act. It certifies unions and deals with other issues related to the acquisition and maintenance and termination of bargaining rights. But you might be surprised to know what proportion of the workload of the Labor Board is actually spent dealing with ESA and OSHA matters. Over the course of time, the level of certification and that kind of activity has fallen way off, and I imagine as a result of that, the legislature has passed more jurisdiction onto the Labor Board in terms of ESA. So orders that are made by an ESA officer are appealable to the Ontario Labor Relations Board, and it's also received jurisdiction under OSHA, so that inspector orders under OSHA are appealable to the Ontario Labor Relations Board. So it actually, the last figures that I saw, it actually spends less than half of its time dealing with Labor Relations Act matters, the sort of classic traditional work of the Labor Board. And it's now, as I say, more focused on the ESA and OSHA stuff. So we'll talk about that. So in terms of collective agreements, obviously this is quite a comprehensive document, often 20, 30, 40 pages long, that's negotiated between the employer and the union. And as I said earlier, it contains most of, but not all, of the terms and conditions of employment. It covers the really important stuff like wages, hours of work, vacation, holidays, and seniority and the like. But there are a number of terms and conditions of employment or areas of the employment relationship that are not covered in the collective agreement. So where do those other items come from? Sorry, Rick?
Personnel policies.
Right. That is generally true. So it's completely appropriate that personnel policies fill in, if you like, between the clauses of the collective agreement. The policies can't contradict the collective agreement, because if you remember my descending order chart, the collective agreement was higher than the employer policy item. But as I said, the collective agreement, it has, let's say, 30 articles. Those 30 articles don't completely describe every aspect of the employment relationship of the bargaining unit employee with the employer. Now, what happens if there is a gap between two collective agreement articles and there's no personnel policy? What happens then? And there's an issue. There's some sort of an issue or an element of the employment relationship that falls within that gap, but it hasn't been filled, as I say, with a personnel policy. How do you deal with that? And let's say an issue comes up. Collective agreement doesn't cover it. Personnel policy doesn't cover it. It could be common law, but sometimes there isn't a case on point, or there's just nothing that you can look at there. Carol? Yes, arbitrators deal with grievances which, at least classically, should be based on an alleged breach of a term of the collective agreement. So we're talking about something that falls between the terms. So any other ideas as to... Sorry? Memorandum of settlement. Again, let's assume that it's not covered. There's just a gap. There's a vacuum. Gail? Employment Standards Act, if it covers, if it falls within that gap, but let's assume it doesn't. Keep going. Any other ideas? Okay, so Scott has said past practice, and that, I think, is part of the answer. There's quite a lot of arbitration law about situations where a certain dispute has arisen, let's say about vacation pay, or it could be almost anything, and the union says that a breach of the collective agreement has occurred because they interpret a vacation pay provision in the collective agreement a certain way, and they say that you employer breached that provision, and the employer says no, you got it all wrong, that provision doesn't apply at all, we're in this gap that I'm talking about, and we've always done it this way. This is how our payroll office has administered this aspect of vacation pay for our employees. And so the fact that we have administered it that way and that everyone has viewed that openly would demonstrate that there's no breach of the collective agreement. But there's still something missing here, and that is management rights. Okay? So the default position is management rights. If you can demonstrate that the collective agreement doesn't cover it, let's assume a policy doesn't cover it, let's assume legislation doesn't cover it, then the default position is it's a management right. That's the theory that we operate under in Canada, not just Ontario. So that's good news for employers. So we're going to talk more about collective agreements later on in the course. Dave, did you have a question?
Does management rights not have to be backed up by something rather than just pulling something out of the sky? It's going to be backed up by legislation, or is it not?
No, it doesn't. That's the critical point. So in a collective agreement, as you know, there is typically a management rights clause. Sometimes it's one sentence long, sometimes it's a page and a half. Frankly, it doesn't matter how long it is, And in fact, I was told once, I've never checked this, I was told once that the Toronto Star collective agreement, which I imagine is as thick as a Toronto phone book, doesn't have a management rights clause. And why? You don't need one because of this default. It's called the residual theory of management rights. So the concept is that management rights reside in the employer to operate the enterprise and to manage the employees and direct the employees, except to the extent that those rights are detracted from or affected in any way by primarily the collective agreement. So in the example I was giving you, there was a gap between two terms of the collective agreement. No policy applied, no legislation applied, no past practice applied. It's your management right to do whatever is required to manage within that gap. That's a really critical point. Yes, Dave?
It would have to be at some level of fairness and consistency of past practices.
Well,
Like, I guess that's the question.
yeah. Sometimes that is determined by the wording of the management rights clause itself. So believe it or not, the worst wording that you can have in a management rights clause is that management will exercise its management rights in a reasonable manner. I mean, that sounds vague and bland and good. It's the worst wording you can have. Why? Because if the union and employees can't find anything else in the collective agreement to hang their hat on, they just grieve that you exercised your management rights in an unreasonable manner. They have a hook in the collective agreement upon which they can hang a grievance. The more usual language is, management rights shall be exercised in accordance with this collective agreement. That doesn't give the union and the employees really anything. It just confirms that the collective agreement is going to be administered in accordance with the collective agreement. You know, it's pretty obvious. But you're right, Dave. I mean, even if you have good wording in the management rights clause, but there's been an inconsistent past practice, or there's a past practice that is grossly unreasonable, you could get a grievance on that. It would be iffy legally, and I think there'd be pretty good arguments. I mean, everything depends on the facts, as you know, but there'd be pretty good arguments that there isn't a valid grievance there, and that management rights is management rights, and as long as you've complied with whatever language appears in the management rights clause, you're good. But unions and union council can be very inventive in terms of their ability to create arguments and sometimes try to make mountains out of molehills. Don't get it wrong, I'm big fans of unions because they basically feed my family. Or at least help in feeding my family. So that's what I was going to say at this point about collective agreements. Employment contracts. Well, let's ask the question: how many people in the room have an employment contract, that are on an employment contract with their? Okay, so 3 or so. All right, and so there are municipalities in the room, obviously, that use employment contracts. Is it mainly for the senior people, I imagine? So middle managers and lower managers, probably not. That's the usual setup in municipalities, I find. But where they do exist, well, technically there is an employment contract even if it's not in writing. When I, of course, say employment contract, I'm inferring that it's in writing. But in law, there is an employment contract, the terms of which may be found in multiple places: employer policies, employer practices, oral agreements, and of course that's why it can be risky to not write down the terms of the employment relationship, because if a dispute unfolds, there's all these evidentiary issues about what the terms actually were. Whereas if you have a written employment agreement, at least you have it down in black and white. There still may be argument about what the terms mean, because the English language being what it is, it's not absolutely 100% clear sometimes what a word or strings of words actually mean, and they're susceptible of different interpretations and so on. But you've taken, if you write down the employment agreements, or if you use employment contracts, you go a long way to eliminating or at least reducing significantly the amount of dispute over what the actual terms and conditions of employment are. So I do encourage, I tell my clients that employment contracts are a good thing, and I encourage them to use them as much as reasonably possible. I think that there is a reluctance, which I understand, to put what might appear to be a lengthy legal type document in front of a first line supervisor, for example. It just isn't how things have worked traditionally, and it might be intimidating. So I think there's a reluctance to use employment contracts at that level. But one of the main benefits of an employment contract is that a well-drafted one will contain termination provisions, so that if there is a termination, especially a termination without cause, then the employment contract will address that specifically. And if it's well drafted, it will be crystal clear what the employee's entitlement is in the event of a termination without cause. That eliminates a lot of legal stuff in terms of litigating what the reasonable period of notice is and that sort of thing. Carol?
Could you have an employment contract for an existing employee? Because I mean, normally one would assume that an employment contract is for an employer.
Right.
Could you legally sort of require existing employees to enter into?
So the question is, can the employer require legally existing employees as opposed to new employees to enter into employment contracts? The answer is yes, with one condition, and it's tough to do. It can be done. The legal requirement is that there be what's called fresh consideration. You may have heard that term. It's a legal concept, which essentially means that if you, the employer, want to, change at least to some extent the terms of the employment agreement, even to the extent of just taking oral terms and putting them in writing, you need to give something for that to make the bargain. That's sort of the concept. So, I've been involved in the drafting of employment contracts for existing employees where the employer provided an extra week of vacation, or there could be a cash payment. But there has to be something flowing which can be pointed to as being the consideration for the bargain, and that will make the contract enforceable. In the absence of that, it's unlikely to be enforceable. Even if the employee says, "Sure, I'll sign that. I don't care." Later, if there's a problem, they may care because they may have lost some rights. I mean, it would be typical that the new employment written contract isn't exactly the same as what the oral terms are, and that in fact there is some reduction of employee rights, often in the area of termination. So it's a very tricky thing to do, and you can imagine that the natural human reaction of the employee is, what's this? I was hired 2 years ago, nobody's saying anything about employment contracts. Where's this coming from? So I mean, it's a shock, and it's difficult to manage. It can be done if the organization has adopted a new policy, so to speak, of having. I've acted in restructuring situations for municipalities where the new municipality has adopted the policy or the view that all its senior people, like director level people, should be on employment contracts. And where it gets really tricky is where an employee has been hired on what's legally considered to be an indefinite hiring, not time limited, and then the employer for some reason wants to put a time limited term contract in place. That's very difficult, because that's a fundamental change in the relationship. So the risk that you run as the employer in trying to do this is that the employee takes the position that you have breached a fundamental term of the employment contract, and therefore they've been constructively dismissed. And suddenly you've lost an employee, perhaps a key employee, and you're looking at a wrongful dismissal lawsuit. So that's the sort of worst case scenario. And we're going to talk about constructive dismissal later on, but I think you probably generally have a sense of what it might be. Rick?
Is it sort of typical that your CAO contracts have terms in them, but below that there may be these indefinite contracts, or is that?
When you say terms, do you mean termination terms?
I mean like a period, like so.
Oh, a limited period.
For a 5-year contract, whereas your directors you hire
With indefinite. Yeah, I've seen that. I don't know that I could say it's the norm. I mean, I certainly know of many CAO contracts that are indefinite as well. So it's a scattered pattern, I would say. Yes, Janet.
Is it good practice to enter into employment contracts with subcontractors? Like if you hire out for contracted services for snow plowing in the winter or grass cutting in the summer?
Right. So the question is it good practice to have employment contracts for subcontractors? I would say, first of all, they're not employment contracts. They're just contracts, because these people are not likely your employees. They're people you're hiring to provide services to the municipality. And so the answer would be absolutely yes, because you can get yourself in a real mess without, it's just certainty and proof of what the terms of the deal are.
Can I just extend, you might be getting into this later.
Okay.
When you hire a contractor,
Yes?
would we have to cover them under WSIB?
Yes.
Yeah, they wouldn't have, or unless they prove
Well, they can get what's it called, a certificate of clearance, a clearance certificate. If they provide that, then you're okay. That's right. But in the absence of that, and there's a workplace accident involving one of their employees, it may well end up on your WSIB account. Right. Okay, any other questions? Yes, Tracy?
If it's determined that we don't have employment contracts and it's something we want to do moving forward,
Yes.
are there any legal issues with the next person that's hired has an employment contract but no other employees do?
So the question was, if the municipality doesn't have employment contracts but decides that it wants to move in that direction and starts using them for the purpose of new employees, are there any legal issues around that? The short answer is no. That would probably be the way to do it, because you're not likely going to want to get into this mucky area that I've talked about of trying to use contracts for existing employees. But that's the way to do it. You just start the practice, and over the course of time, your workforce will become will be covered by contracts. But just make sure you get a good contract template designed up front, and also be aware that sometimes you can't just use a template without regard to the individual circumstances. I've seen contracts that were obviously designed for this situation transplanted over here, and the translation doesn't work well, so people have to put their mind to it. Yes, Rick?
What's the relationship between the letter of offer or hiring letter and the contract? Can they be the same document, or do they refer to each other, or how is that?
I would say, well, I've seen a whole bunch of things in that regard, but the best practice would be, and I think most people in the room would agree that it may be a little intimidating to a job candidate if you lay a big employment contract on them right up front. So most people don't do that. They will provide a letter of offer, But if you intend to have them enter into an employment agreement, it's critical that you make mention of that in the letter of offer, so that it's not a big surprise, and that the letter of offer is subject to the entry into the employment contract. That's sort of the standard best practice. Okay, anything else? All right. So now we're going to talk about the various types of common law. And as I said, traditionally common law is thought of as court-made law, but I've actually, just for the purposes of this session and to try to sort of put a few things straight, hopefully in your mind, I've expanded it. But we'll talk about the first traditional category first. So as I said, common law is typically judge-made law. And there are different layers of courts, which we're going to get to in a moment. But, you know, they deal with individual cases, different facts, and calling for, in some cases, interpretation of statutes and the like. There's a legal principle called stare decisis, which means that there is a pecking order of courts. So, not surprisingly, the Supreme Court of Canada is the Supreme Court, as the name would imply, in the country, and what the Supreme Court of Canada says goes or is binding on all Canadian courts, even the provincial courts of appeal. But then, staying with Ontario, we have the Ontario Court of Appeal, and it is binding on all courts below it, but it has to listen to what the Supreme Court of Canada says. And it is what's called persuasive. So if the Ontario Court of Appeal makes a particular pronouncement or decision on an issue, and then later on an issue in New Brunswick arises, which is pretty much the same issue, the Ontario Court of Appeal isn't binding on any New Brunswick court, including their Court of Appeal, but it's persuasive. That's the phrase that's used. And then all other courts, what that means is the decisions of all other courts are persuasive on each other. So you have this pecking order, but if you have a lateral court making a decision, the decision of a lateral court is persuasive as opposed to binding, if you follow me. So the other, as a practical matter, the other in the civil stream, which is where I practice, the other courts are the Superior Court of Justice. It used to be called the Supreme Court of Ontario, but about 15 or so years ago it was changed to the Superior Court of Justice. And then, of course, there's the Small Claims Court. And the Small Claims Court has jurisdiction up to $25,000. And the Superior Court of Justice is everything north of that. There's also the Divisional Court, which is a branch of the Superior Court of Justice, and it deals with, in terms of employment law, it deals with, sometimes there's statutory appeals, but mainly it deals with what are called judicial review proceedings. You may have heard that phrase, and we're going to cover it later on. But it's a process whereby a tribunal has made a decision and someone's unhappy with it, and they apply to the courts for judicial review. That kind of case will go to this divisional court. So that's a quick run through of the court system in Ontario. But then there's a huge body of law that is made in Ontario by administrative boards or tribunals. You can't imagine how big it is. In fact, most of the justice, if you want to think sort of holistically, most of the justice in this country, and we'll talk about the province, is delivered through administrative tribunals as opposed to courts. The courts actually don't have a huge volume. They do a lot of criminal work, as you know, which isn't relevant to what we're talking about, but in the civil stream they do some stuff, but there's much more decision-making delivered, or adjudication and decision-making delivered through administrative boards. So as I mentioned earlier, the Ontario Labour Relations Board has jurisdiction vis-a-vis the ESA, OSHA, and the Labour Relations Act. The Human Rights Tribunal is obviously the tribunal that administers and enforces the Human Rights Code. The Workplace Safety and Insurance Appeals Tribunal, sometimes referred to as WUSIAT, is the, not the only, but is the highest level appeal tribunal in the WSIB system. Has anyone ever been to WSIAT? Okay. And then you have arbitrators, and if you're a unionized employer, what the arbitrators are doing and saying is very important to you, because they are really creating the law that relates most directly to the interpretation of your collective agreement. Well, two collective agreements generally, not necessarily yours. Obviously, if you get an arbitrator's decision under your collective agreement, specifically because a grievance was filed and went through the system, that's very important, because it will likely, in a lot of cases, it'll shed some light about how your particular agreement is to be interpreted. And arbitrators, it was decided by the Supreme Court of Canada roughly 10 years ago that arbitrators have the ability to apply and enforce all employment-related legislation. So that if there is an ESA issue, that one of your bargaining unit employees is of the view that you have breached the Employment Standards Act, not the collective agreement, but the Employment Standards Act, that has to be processed by way of a grievance. They will be sent home by the Employment Standards branch, which administers the ESA. They'll be told, no, you have to file a grievance. So you can get grievances that are based exclusively on an alleged breach of legislation as opposed to a breach of a collective agreement. Usually it's a combination of the two. Okay? So just focusing in on the Labor Board for a moment. The jurisdiction of the Labor Board relates to certification and decertification of unions. It relates to, there are cases that go before the Labor Board dealing with successor, usually employers. There is a small piece related to successor unions, but the usual issue is successor employers. So if, and this can apply in the municipal world, especially when there's restructuring going on and a piece of the municipality is broken off in some fashion as a result of the restructuring, and it ends up being non-union, but let's say some of the employees in that new unit used to be members of CUPE over here, and so CUPE may try to follow its bargaining rights from where it sits now over to the new unit. That would be called a successor rights case. So the Labor Board, if those aren't resolved, the Labor Board will decide those. And there's things called unfair labor practices, which are alleged breaches of the Labor Relations Act. So those are sort of the main things that the Labor Board does in relation to unionized workforces. And then in terms of the non-union side, as I've mentioned, it has jurisdiction under ESA and OSHA, and we're going to cover that later in the course. So finally, on employer policy, you know, we're talking about personnel policies covering everything from how you pay your vacation payout to social media policies are common these days, to discrimination, harassment policies, all those kinds. There's a whole raft of them that you know, can be included in your policy manual. As I mentioned before, they can't conflict with the collective agreement or legislation. To the extent that they do, they'll be ineffective. So there's no point writing them that way, because there's not going to be any legal effect that flows from it. They often are considered in legal proceedings, be it an arbitration case or a wrongful dismissal case, or sometimes a human rights case. And as I mentioned earlier, they will, in virtually every case, they will assist your legal position if you're able to demonstrate that you had a policy in place and that it was communicated. Don't lose sight of that fact. There's no point in drafting the world's best policy and then putting it in your top left-hand desk drawer. If nobody knows about it, it has no meaning. And I've been involved in a number of cases, arbitration cases, where the employer disciplined on the basis of a policy. We got to hearing, and the griever is giving evidence, and the griever says, I never saw the policy. So all of a sudden, the whole basis, or a good portion of the basis for your discipline, if that is true, falls away. So you have to be really cognizant of communicating the policies as they're created and as they're revised, and ideally getting some evidence that they actually were transmitted electronically or in hard copy or in a meeting or posted on the wall, or whatever it means. There's no magic means to get policies out to your employees, but the best means are those that are provable after the fact. So I mean, I suppose the idea would be that a new policy is created, you have a staff meeting, copies are handed out, and there's a sign-off sheet for that meeting to show that Joe Smith was at the meeting. So if you discipline Joe Smith later, you can demonstrate that beyond a doubt he had knowledge of that particular policy. I mean, that's sort of the ideal. You may not be able to get there, but think about ways that you can prove the fact that your policies have gone out. All right. We talked about, this slide says, Regional Manager Dan Blomquist introduces a disgruntled employee to his new open door policy. So I mentioned earlier that there are very few, surprisingly few, required policies. You have to have an occupational health and safety policy and a program to implement that policy. So the policy is usually a high-level document. The program is more detailed, tailored to your workplace. You have to have, under what is usually referred to as Bill 168, a workplace violence policy and program, and also under 168, a workplace harassment policy and program. That's it in terms of mandatory policies. Now, the caveat on that is the AODA requires a customer service policy and so on, but I'm not going there because it's not technically in the employment realm, but it is a required policy. But as I mentioned earlier, there's a raft of other policies that are best practice, good to have, and probably at the top of that list is an anti-discrimination, anti-harassment policy. I mean, you're absolutely crazy if you don't have one of those, because if you have a case that involves human rights of any nature, that'll be the first question. Let's see the policy. But there's multiple policies beyond that that would be in the best practices category. And as the slide says, you need to keep them up to date, and I know that's hard to do, but you need to keep them up to date. And is there any sharing of, I mean, other than informal sharing from neighboring municipalities or something in terms of policies, is there any sort of big database that's available in the municipal world in Ontario that people can tap into to get good policies? Does OMRA? Yes, Tracy?
The MFOA is working on a virtual library, so the more that we contribute resources to them, the more that they will publish.
Is that the financial officers? MMOA, okay.
MFOA,
MM,
Municipal Finance Officers Association.
okay, okay. That's the kind of initiative that I think has to happen. I'm part of a provincial board, and we've hired a law firm to create a sort of template personnel manual, top to bottom, and it's like the index is 3 pages long. It's a great service that, you know, organizations like the one you've just mentioned can provide, because it's a huge time and money saver for the membership. So let's move on to a couple of differences. There's many differences between the unionized and the non-union world, but the two that I've focused in on are termination of employment and how disputes are resolved. So in the basic difference between the unionized and the non-union world in terms of termination of employment is that in the unionized world, you cannot terminate an employee without cause. It's not an option. Some people would say that produces a job for life situation, and maybe it does, because the only way that you can terminate, as opposed to layoff, but I'm saying termination related to performance or some such thing, a unionized employee is with cause, and that's hard to get to. The arbitrators don't hand that out like candy. So that's the main difference. And I've still got employers that I've acted for years that phone up and want to know how much severance a bargaining unit employee gets if they get fired. Like, they just don't get it. That's a key point. However, if you are a non-union employer, or if you're a unionized employer with non-union employees, which of course you would be, you can terminate someone's employment without cause. And the minimum standards, and we're going to talk about this in a couple of the upcoming sessions, the minimum standards are, of course, the Employment Standards Act, and we'll go through what those are later today. But there may be the requirement to give what's called reasonable notice over and above the Employment Standards Act minimum requirements, and that's generally referred to as the law of wrongful dismissal. And we're going to cover that in the last session in the program. So we won't go into all the details. There's lots of law and details around what reasonable notice is and how you calculate it and so on. So that's the big difference. Termination is difficult, especially in the case of a unionized employee, but even non-union, because it really is the intersection of legislation, such as the Employment Standards Act, common law, such as the law of wrongful dismissal, and if there's an employment contract, written or unwritten, but especially if it's written, then that will be relevant to the employee's entitlements as well. So it becomes complex, or it can become complex very quickly because of those three things sort of coming together. So this slide talks about reasonable notice, and I think I'm just going to skip over it because, as I say, we're going to be delving into that in some detail in future modules. So then there's another concept called frustration of contract, and this is not well understood. What frustration of contract is about, or it's premised on the fact that an employment contract is really very simple. You're my employee, you come and perform services for me, and for that I pay you money. That's an employment contract at its root. And if one party, the employee, fails to do what he or she was supposed to do, show up and provide services, for a lengthy period of time, and if the evidence shows that it's not likely that that person's going to be able to come in anytime soon, I mean, I'm being casual here in my language, and we'll talk about this in greater detail later on, then the law in some circumstances will say the employment contract is frustrated. Often it's illness or injury that prohibits the employee. Genuinely, we're not talking about situations where the employee is faking or anything. They got very ill and they haven't been at work for 2 or 3 years. And there's some medical evidence provided that shows that that's not likely to change. The employer can take the position that the employment contract is frustrated. That's different from a cause or a no-cause termination. And when frustration occurs, the magic is that there is no wrongful dismissal liability. There's no damages payable. However, the Employment Standards Act says, because it was specifically amended a number of years ago to say this, that if an employment contract is frustrated by reason of illness or injury, then ESA must be complied with. So any termination or severance entitlements under the ESA have to be fulfilled. But there's no wrongful dismissal liability over and above. It's an interesting concept. It's not accessed that often. We're going to talk about it later this afternoon in connection with attendance management because it comes into play there. So that was all I was going to say at this stage about termination, much more to come later on. In terms of dispute resolution, obviously under a collective agreement, if there is a dispute related to either the interpretation and application of the collective agreement or, as I said earlier, employment legislation, then there's a grievance filed. And I think you probably all know or have a sense of what a grievance is. It gets reduced to writing. It goes through a series of steps in a grievance procedure, and if it's not settled as a result of that, then it goes to arbitration. We're going to talk about that in some detail in the second to last module. Rick?
Just go back to that frustration thing.
Yes.
Does that tie into the requirement for accommodation?
Yeah.
Come into conflict with that?
Well, hopefully not conflict, but you're absolutely right. Accommodation is something that the employer needs to turn its mind to before it takes the position that the employment contract has been frustrated. Because almost always, if illness or injury is the thing that's keeping the employee from coming to work, they're probably disabled under the Human Rights Code, therefore they're entitled to accommodation. So yeah, you have to turn your mind to it. As a practical matter, it often doesn't rear its head because the person is so ill or injured that there's no accommodation that can occur. It becomes a non-issue, if you know what I mean. But absolutely, you have to turn your mind to it and address it if required. Yeah. Okay, so dispute resolution in the non-union world it's often very fuzzy and vague, and there may even not be a channel. Not every municipality, in my experience, has sort of a non-union grievance procedure. Some do. Some have complaint procedures. Usually they're not called grievance procedures because that looks too much like a collective agreement thing. But not every municipality does, but some do. I mean, I've seen them that allow an employee with an issue, even an ex-employee in some cases, appear before council in order to argue their case and try to get council to remedy whatever the alleged wrong is. Or obviously ex-employees sue their employers, but sometimes existing employees sue their employers. Doesn't happen that much, but it does happen. So the first case that I did at the Human Rights Tribunal as counsel, when I returned to practice in 2010, was for a health unit that was at the receiving end of a Human Rights Tribunal application from an existing employee alleging discrimination on the basis of age. She alleged that she had not been hired for a particular position because she was older. So it happens. It happens more now than it used to 5 years, 10 years, 15 years ago. And just as a postscript on that, there is some law out there that says that the initiation of legal proceedings by an employee against his or her employer is cause for termination. I think that's old law now. I don't know that that really is the current state of things. But there's a few cases around to that effect. So just a couple of concluding comments, or a couple of areas. A theme that I wanted to emphasize up front is that the employer is the custodian of the workplace. And I mean, I guess that's sort of obvious, but it's something that decision makers take note of. And so we're going to talk about the internal responsibility system under OSHA. And not surprisingly, the employer of the worker, employer, and supervisor has by far the biggest list of responsibilities. Why? Well, the employer is in control of the workplace. They have the ability to design it, to create it physically, to manage and direct the employees who work within the physical space. It's really a control issue. Human Rights Code. Probably heard about the poisoned workplace. It's a concept that has seeped into human rights jurisprudence and also wrongful dismissal jurisprudence. the general idea is that a workplace became poisoned for some reason. Disability, there were inappropriate comments being made on a daily basis by managers about disabled employees, or it was a sexually charged workplace. There were inappropriate posters up on the wall and sexually charged jokes being told on a regular basis. And from a woman's perspective, that poisoned the workplace. That concept is all built around the fact that the employer has control of the workplace. And in fact, the case law has, as we'll talk about, has evolved to the point, if you want to talk about harassment, that the employer has a positive obligation to create and maintain a harassment-free workplace. It doesn't say that in the Human Rights Code, but that's how Section 5, which is the basic section that relates to employment, has been interpreted by the courts and by the Human Rights Tribunal. Why? The employer is in charge of the workplace, and if harassment develops, it is the party, not the co-workers or the employee who's aggrieved or whatever. It's the employer that has the ability to manage that and to get rid of harassment that may develop. What goes along with that, not exactly on point, but related, is that the courts and tribunals have acknowledged that there's a power imbalance, as the slide demonstrates. There's a power imbalance in the employment relationship, probably throughout the relationship, but especially at the time of its termination. That's when employees are vulnerable. And so the Supreme Court of Canada and other courts have, over the last few years, created this concept of good faith dealing, that in the manner, the phrase is, in the manner of termination, the employer owes a duty of good faith to the employee. So what does that mean? That means you don't send the pink slip to the employee by taxi. It doesn't mean that they read about their job being available before they know about that in the newspaper. These are obvious examples, but believe it or not, some employers do these things. And so that's created this duty of good faith, and we'll talk more about that in the wrongful dismissal termination section. But the short story is, if you breach that duty of good faith, and if there's evidence that the employee has suffered as a result, there will be damages awarded for that. There will be increased liabilities. So those are sort of issues that cut across the areas that we're going to be talking about in greater detail throughout this course. And the final area is that it isn't a completely one-way street. There are employee duties. And this probably applies more in the private sector, frankly, than in the municipal sector, but I thought it was worth mentioning. There are actually two types of employees. There are fiduciary employees and there are regular employees. Fiduciaries are typically, not always, but typically senior level employees who are at the core of the employer's business because of their relationship with customers and clients, or because of knowledge that they have about how the business makes money, or for some other or some combination of reasons that creates this fiduciary status. And if you're, as an employee, if you're found to be a fiduciary, you have a much higher duty to your employer or ex-employer. You have a duty not to compete. You have a duty not to solicit employees when you start your new business down the street, and that sort of thing. So you may hear, not so much in this course, but otherwise, the term fiduciary. So that's what that's about. Regular employees, though, don't get off scot-free, and they will almost always be held to a duty of confidentiality, so that if they leave the municipality or the business, they can't go around blabbing about confidential matters that they learn during the course of their employment. And if they do, they may get sued, and there may be damages, liability, and that sort of thing. That's the main duty that regular employees have. By contract, it's not unusual in employment contracts to see what's called a non-solicitation clause. Not so much in the municipal world, but elsewhere, which is a promise by the employee that if they leave, they won't solicit customers or employees to assist them in their new competing business. And then the highest level of undertaking is non-competition, and that's a clause that essentially says if I leave you as your employee, I won't compete in a certain geographic area in a certain business for a certain period of time. Again, not overly applicable to the municipal sector, but I thought I'd just mention it briefly because you may hear these terms, non-solicitation, non-competition, and so on. That's really what they're about. So they're a combination of contractual obligations that usually appear in carefully drafted employment agreements, but there's also common law elements too, and the courts will apply these duties even in the absence of a specific undertaking to not pursue these particular things. So this gas tops thing, this is an extreme case. A bunch of employees work for gas tops, I forget what business they were in, but they broke off and started a competing business. They gave 2 weeks notice to gas tops. Now, if you look in the Employment Standards Act, that's all you got to give as an employee leaving. But remember, the Employment Standards Act is the minimum. So gas tops, and these people ripped the guts out of gas tops business. Like they really sagged as a result of this large group. I think it was 10 or 15 employees that left and set up a competing business. Gas tops sued, and it was found that some of them were fiduciaries, some of them were regular employees, but the total damages award when the dust settled was a shade under $20 million against the employees. So they got hammered, and I think that went to the Court of Appeal and was affirmed. So it can be serious business. It was found that the employee should have given gas tops 10 months notice. Why? Because they were so critical to gas tops business that gas tops needed 10 months to go out, recruit, replace, train, and so on. Do you have a question, Dave?
So there was critical mass there. It wasn't just one.
Wasn't just one.
Yeah.
That's right.
So, I mean, they had really formalized a new company in their leaving.
Absolutely. Yeah.
Where I guess the question with the issue of confidentiality, was this one individual at the bottom of the rung? That's a very difficult one to
It is. It is, and it's hard, frankly, to enforce the confidentiality obligation because, frankly, it's hard to prove damages, especially if you're a municipal sector employer. If you're a private sector and you can show that this person has gone around bad-mouthing you to customers and you've lost customers, that's clearer. But still, even difficult in that case. All right. So, just wrapping up the overview session, our overall program goals are to provide to you a working knowledge. You're not going to become labor lawyers as a result of this, but you should leave this course after the 4 days with a good working knowledge of virtually every main area of HR law. And, you know, I think what is really critical, and this is a good way to think about it, especially if you're not centrally involved in the HR matters at your municipality, but you're peripherally involved, it's all about issue identification. A certain situation occurs in your workplace, and something goes off in your mind. Because you were in this course, something goes off. Oh, there might be a human rights issue here. I better get some advice, either internally or externally. I mean, if we can get you to that point, I think we will have sort of succeeded in providing a deliverable on the course. We're going to try to make it interesting and informative. As you saw, we've got a few cartoons included in the PowerPoints to lighten things up, and we've got a few YouTube links. I think there's a couple of excerpts from the TV program The Office and that sort of thing. So I'm hooked into the wireless here. I think we'll be able to view those. But certainly at some point you'll be able to access this material online, and those links will be live. And we're going to try to have some fun. So let's leave it there, and we'll move on to the next program shortly.